Hello. Welcome back. All right. Another need we can talk about is generally land use reform.
What about sustainable development?
We can put that under need for development. We can put sustainable development. That's the word. Sustainable development was a big part of the 1992 Rio Conference. The Rio Declaration emphasized sustainable development. Did you learn about those? The 1972 Stockholm Conference and the 1992 Rio Declaration? Land use. Land use? Land use is how you use land, but under legal regulation. So we're talking about things like agricultural concessions.
Irrigation.
Yeah, we're talking about concessions for agriculture and logging. Logging is cutting trees. It's when the government, by regulation, says this land should be used in this way. So for agriculture or for logging, they can put restrictions sometimes saying there shouldn't be certain activities on this land. Things like natural protected areas would fall under land use. When you reserve an entire area and say there will be no development because this is a protected national park, this is also part of land use. Land use is everything under law which declares a use for a land. So it goes hand in hand with land reform generally. Protecting owners of land. All this will fall under land use. Forestry use, yeah, logging and forestry use. There's so many laws. There are many laws in Burma dealing with how land can be used and who can own land and what they can do on it. So it's a broad topic. And of course, the big one you've talked about in many classes. Social protection. So especially in developing countries, social protection is always a major part of environmental law because so many groups in developing countries, they rely on the environment around them more than other countries. So you have many villages where the environment around the village is part of their life. And if you destroyed the environment around them, you would destroy the livelihood of the village. So there needs to be special protections for people that rely on the environment. Populations rely on the environment. And need special protection. Did you talk in Bobby's class about the kind of protections you have for groups that rely on the environment around them?
No.
examples of the kind of protections. For example, this one. Did you learn this word?
No.
FPIC?
FPIC.
No. Foreign.
Yes. All right, I need to write this a little higher. FPIC. Free. Prior.
Almost free and prior.
Informed consent. FPIC means free and prior informed consent. This means when, before a company comes into a rural area to develop it in a certain way, they need to consult with the local population and ideally get free and prior informed consent. And when we learn this term, it used to be just PIC. For many years it was just prior informed consent, and only recently there's been a movement to add the free. Do you know what the term free means in this context?
Free consent.
Free consent. Very similar like contract. If people just give their prior informed consent, usually companies just interpreted that. They would go to the population and they would say, this is what we're going to do. Thank you very much. And they just leave. And they say, yeah, we got their informed consent. They heard about it. They nodded their head. That was enough. But now we emphasize on the free. We want to make sure that it's really their consent. So when we look at cases involving FPIC, we look at each term. You know, are they actually consenting? Is this what the population really wants? Usually that means the population should get some benefit out of it too, to give their consent. Are they informed? Does the population really know what's going to happen? Is it prior? Does this happen before the development starts? If it happens before, that gives the company the chance to change the practice so that the local population and the company can work together to make a project that's good for everybody. And then free. You want to make sure that that it's free consent, that they weren't coerced and that they actually gave their consent voluntarily. FPIC. So this is one kind of social method for social protection. But there are other methods to get social protection of groups, especially for these populations. The reason why it's important for developing countries is because of how much populations rely on the environment. So their entire life depends on the environment around them. So consultations, consent, special protections. All right. Can anyone think? So this is the list I made of needs that are special for developing countries, or like Burma, when they're practicing environmental law. These are certain needs that are special to developing countries that we need to think about. Can you think of any others that aren't on my list that you might think that are like these kinds of needs? So remember, environmental law is about protecting the environment.
What about protection of the atmosphere?
The atmosphere? Right, but what about the kind of law? Now we got two categories. These are the environmental issues, and then these are the legal issues that come up trying to protect. So this is what you want to protect. This is how you want to protect it. So how would you want, so these are a list of things I thought was important for developing countries to practice in how they protect these issues. You need institutional capacity. No matter what you protect, you need agencies that have the expertise and money to do the job, to do a good job. We need to worry about money coming in, controlling for development projects. How do we treat this money to give protections for the environment? We do need to think about development. We can't just stop all development in Burma. We need to think about how land is used, no matter what the issue is. What's the land use, and are there any dangers? You know, abuses of like people not having protection for their land, and then social protection for vulnerable groups. So are there any other things you can think of how Burma should regulate the environment. That might be an issue that are similar to this is a list I made.
The government should act efficiently and use money properly.
Okay.
Then to support the development.
Okay, so that sounds like part of institutional capacity and need for development. But yeah, we need the government to be able to be competent to regulate the environment. The environment cannot regulate itself. So you need to have.
What about teacher? We ask them to follow OECD guideline.
The OECD.
Guideline. To follow according to OECD guideline.
Yes, international standards.
International standards.
Well, we didn't talk about the balance between domestic and international environmental law. So I want to have at least one or a few classes on some international environmental law. There are different issues between domestic environmental law and international environmental law. I think one thing that's important that we can study with international environmental law is what's called bilateral environmental agreements. So this is an issue like if you had a river that ran between China and Burma, Burma cannot deal with this issue by itself. You need China and Burma to work together. So this is called a bilateral issue. And this would be under international environmental law. Burma cannot control this river by itself. So you need to do it under international law with the two governments working together. I mean, Thailand, this is very common with something like rivers or mountains. The river between Thailand and Burma, what's the name of the border river? Yeah, so this river, I'm almost sure, there's a bilateral agreement between Thailand and Burma for control over this river and for pollution issues and all sorts, many issues come up that states have to agree on. And there are special rules you need because it's not under domestic law. Everything has to be done under international law. And when you do deal with problems under international law, it's always more complicated. You have to get people coming together, and it's like drafting a treaty. And everything we talked about was treaty law. So it's hard to enforce because there's not a government over them. The two governments have to agree. So there's special issues with international environmental law. There's bilateral, and then there's multilateral issues. So multilateral issues would be like the wildlife trade here. There are people in Burma that are they're capturing animals in Burma and then they're selling them to China and to other countries and to Thailand. This is a multilateral issue because it can go to many different countries. There's a treaty called CITES. CITES is the name of the treaty. The Convention on the International Trade of Endangered Species. Convention on the International Trade of Endangered Species. So this is the treaty that deals with these traded species. It's a multilateral treaty that can protect some of these species. And of course, climate change. Climate change has a huge treaty program called the International Framework Convention on Climate Change, and then the Kyoto Protocol. So these are multilateral treaties that many states have signed that can protect Burma for these certain environmental issues, but it's under international environmental law, which works very differently than domestic environmental law. Domestic environmental law is working through these agencies. Is working through government agencies, mostly, or courts under common law. International environmental law is working through multilateral treaties, and then these kind of foundations like the World Bank and JEF that give money to Burma or some development project so that they can administer it through through the treaty. But they work differently. So we'll do some sections on international environmental law to talk about the special rules for these kind of situations.
By the way, multilateral issue means like Mekong River.
Multilateral issue is like under a treaty.
Many countries.
Yeah, many countries. Multilateral means many countries.
More than 2 countries.
That's right. Bilateral means 2 countries. That's right. Bilateral means 2 countries. Multilateral means many countries. So a bilateral issue is like a river. Like a river between, yeah, like between Thailand and Burma. Multilateral issue is like climate change or species. Or species, animal trade.
Teacher,
Yes.
in Brazil, they have Amazon rainforest there, and this is international material street or just
I'm sure Brazil,
because this
they have the forest crosses boundaries. So, but a lot, you would need to break it down into different issues. Probably the forest itself, Brazil has domestic law on its own forest. Like Burma's forests will be controlled under the Ministry of Forestry, under domestic law. But the Amazon River may cross through the Amazon River does cross through different states. So the Amazon River will be under a multilateral treaty. And the similar like river. The rivers, I think there are a number of rivers in Burma that flow through different countries.
Mekong.
Yeah, the Mekong is, I think that's the big one. And that won't even be bilateral. Sometimes there's something in between, which you might call a regional treaty. The Mekong River should be controlled under a treaty with maybe 4 or 5 countries. 4 or 5. We can go to a map later and count. But this river, to be controlled well, it should have a treaty with all the states. So it's not a big multilateral. It's what we call a regional treaty. But that's another issue. Okay. So looking at this list, does anyone have any questions? Social protection, land use reform, the need for development, institutional capacity.
That is maybe the rule of law as well.
Yeah,
Institutional capacity.
you can put that. Well, I would go with legal reform and rule of law generally.
The rule of law.
So we need to read about these agencies because I think these agencies are very political. They do not, especially something like the Ministry in Agriculture, do they really follow the rule of law when they're making decisions for agricultural concessions? Or are they very political and only think about money? Development too. Burma has a reputation. It wants to develop very quickly. But that kind of attitude, they're just thinking about making money for the country and the political party keeping their power in the country, which is different than the best interest of the country. Agencies are supposed to think, under rule of law, they think about the best interest of the country and the people in that. So the environment, protecting the environment is part of the best interest of the country. And an independent agency would think about the balancing development with the environmental protection together. So you want not just rule of law, but also independence. So this is part of administrative law. You want agencies that are independent from politics. The more politics becomes involved in agencies, then the more they're only thinking about money and power. The independent agencies will think more about, every agency has a problem with politics and trying to be independent. All right. And then I saw these are some of the major issues, probably the ones we'll look at in this class. we'll look at deforestation. I think you realized, you know, that when we talk about these different environmental issues, we're not only talking about the one little part that's involved. When you're talking about deforestation, we're not only talking about trees being cut down. You know what I mean? I think you learned that, you know, you spent 2 weeks on mining. And I think you learned mining isn't only about getting rocks out of the ground. There are so many issues that become involved. The economy becomes involved. You have the populations living around it. And there's the whole environmental system. If they put mercury to try to help the mining, that mercury then goes out into the environment. So it's not only about getting rocks out of the ground. Deforestation is not only about cutting trees. You also have an economy, you have the population around it. Agriculture is not only about growing crops. We're going to talk, I'm going to mark the most major issues we'll definitely talk about. Mining is a major issue, but I don't know if you need to learn more about it. Yeah, you've spent 2 weeks on it. In oil and gas, but we should talk about deforestation, we should talk about agriculture, we should talk about the dams, and then maybe one of these two, development and wildlife. So these are the 1, 2, 3, 4. So these are the 5 things that we'll definitely talk about, the major issues. And climate change. Maybe one of these two. Yeah, so these are the major 6 topics that we'll definitely want to cover in this class. And then if we have some time, you know, we can talk about some of these other issues.
Are we going to talk about a specific country, the domestic law, environmental law?
Yes, we're going to talk about each of these issues in Burma, largely under domestic law. And then after that, we'll look at some international laws. Well, it depends on the issue. Wildlife may be protected better under international law than domestic law. And climate change is going to be protected better under international law than domestic law. So for certain issues, will be a lot more international law. But like agriculture, this is all, agriculture and forestry are very much domestic law in Burma. Except to the extent you have international investment. That can become an issue. Like the dams, these are international groups that are funding them. So some international law will become involved. And I think some of the groups that are cutting forests, are they international companies? Maybe. Okay, so these are the issues we'll look at. So, for the rest of the class, we're going to start an actual case. We're going to look at a case study. We're going to turn to the common law. So I think this should be some review for you, since you did the common law earlier. Okay, I am going to erase this part. So now we're going to look at how the common law claims for environmental law generally. And I believe you talked about common law claims for mining. A little?
No, for mining. Common law claim for mining.
Yeah, someone suing in a court under a common law claim. So, much of environmental law is statutory because the common law has problems with environmental claims. So that's what we're going to look at when we look at a case. But the common law claims are out there. So I'm going to give an example. This is another river one. I was going to change this to Burmese, but then I learned that it was a real case, so I should probably keep the real case. This is a state in America called Tennessee, and this is a state called North Carolina.
North Carolina.
Yeah. Maybe I'll spell them out. Tennessee and North Carolina. In my Burmese version, this is going to be Shan State, but there's a river that flows between these two states, and it's called the Pigeon River. Pigeon River. There's a mill here. So they make paper. I'll put the name of them. This is Fox Paper Mill. Okay, so Fox Paper Mill. They make paper. And then here are, this is like a neighborhood. There's some houses. There's different neighborhoods along the river. So right around here is a farm. There's a farm here. And the person who lives here, his name is James. James. Yeah, so here's James. And then here's the Fox Paper Mill. All right, so I will read the facts of the case. So James has a farm. It's on the water. It's right on the Pigeon River. And he has a well. He gets his water from a water well. This is a well. The water well is right next to the river. It's not actually in the river, but all the water in the well comes from the river. So James and his family all drink from this well. And then also his animals. He has animals. He has cows and pigs on his farm. And his cows and pigs also drink from the well. And he also uses the well to irrigate, to put water onto his crops. So he has complained, he's complaining that the water, this is part of his complaint, the water, the river and well water are colored. It's colored a weird looking brown color. Brown water. It smells terrible. The water smells terrible. And then he complains that people in the nearby town, people got cancer. So there's a nearby town here, and he has been hearing stories that people in this nearby town have been getting cancer, especially a cancer called leukemia. So James and all the people in the town think that this problem with this color and terrible smell and people getting cancer is coming from Fox Paper Mill. And there used to be lots of trout fishing. Trout is a kind of fish. The fish have died. There used to be a lot of trout fish, which is a fish we can eat. In the past, there were so many fish. And now all these fish have died, so there's no more fishing. And the state put in a warning saying, do not eat the fish. If you catch fish from this river, do not eat it. It's not safe to eat the fish. The state issued a warning not to eat this fish. All right, and yeah, so all the fish have died anyway. The population of the fish has gone lower. So we think there's something bad. So this is 30 miles. It's 30 miles from James to the Fox Paper Mill. All right, so let's talk about the Fox Paper Mill. They take So, have you ever learned how paper is made? They get a bunch of trees and they pulp it, they chop it into little chips, and then you put it in a lot of water. It takes a lot of water and it mixes all the fibers, and then you put something called chlorine to make it white. So, Fox paper mill, 90% of the river water is taken. They take 90% of the water and then they put it in, and then they heat it up and put wood inside the water. So then there's a lot of organic. You know, wood is very made out of living things. There's a lot of wood parts inside the water. And then they add chlorine. Add chlorine to make it white. So chlorine plus biomass. Bio means living, mass means stuff. So chlorine plus biomass equals something called dioxin, which is, some people think this dioxin, if you add chlorine to this biomass, it creates this chemical. And some people claim it makes you sick. Some claim it causes cancer. Other people say it's just fine. I drink it all the time. Okay, so they take 90% of the water, they add all this wood into it, heat it up, put a bunch of chlorine, and then after they take the paper out, then they put the water back into the river. But when it comes out of the river, now the water is very black. It turns the water black and very smelly. You can smell the water. And then the water has these dioxins inside it right when it comes out. And then it flows all the way down. And so now James is complaining. The water is colored around where he is. It smells terrible. And we drink this every day. And we hear people getting cancer in this nearby town. So we think the source of our problem is Fox Paper Mill. That's where we think all this trouble is coming through. So James wants to sue Fox. James wants to sue Fox under some claim, so that he can get money for the change in color, the terrible smell, and the possible risk of getting cancer.
This is a standard.
Yeah, they're paying a cost and Fox is not paying for it. That's right. It's very cheap. You know, river water is free. No one has to pay. So it's very cheap for Fox just to take 90. He's taking almost all the river water, using it, and then putting it right back into the river. Okay, so so Fox has a permit. Fox has a permit. So the government has given Fox permission to use the water like this. He has a permit by the government. But the permit is from a very old law, maybe. Permit only talks about, the permit is only for the color and smell. So the permit, there's some regulation saying as long as you keep the color and smell below this level, we will give you a permit. But the permit does not mention, dioxins. So there's nowhere inside the permit that says anything about this kind of chemical that some people say make you sick. The permit talks about the color and smell, but the permit does not talk about the dioxins. And then there's a law. There's a state law. State law. You cannot put dangerous chemicals in the water. You cannot put dangerous chemicals in the water. But there's no definition of dangerous. It just says generally, you cannot put dangerous chemicals in the water. That's all the law says. So we don't know what dangerous means. Just that there's a law saying you cannot put dangerous chemicals.
where should we put dangerous?
Wherever you put them, not in the water.
Not in the water.
Not in the water. Yeah, I mean, it's a state law. You'll be not in the river. Yeah, not in the river. It's a law about the river. It's a river law, state law about the river. You cannot put, yeah, not just water, in the river. Maybe you can find some other place to put it, but the law says you cannot put dangerous chemicals in the river. But it does not define what dangerous means. Okay, so then the first thing James does is he goes to the state authorities and he says, this is terrible. We have this terrible smell and this people are getting cancer and it's changed the color. Do something. You're the state agency. You can do something. And the state agency says, we've done all we can. They comply with this. They have a permit under state law and we don't think they break this law. So we, the state, there's nothing more we can do. So James wants to bring a lawsuit. Since the state government is not going to solve his issue, he wants to bring a lawsuit. And since it's not under a state law, he will need to use a common law claim. So I'm going to erase this. And let's talk about what common law claims can James use. So did you take torts law, the course?
Risk of public nuisance.
Okay, that's one of them. What's the other? What other kind of nuisance is there?
Risk of contract.
Breach of contract is under contract law. We're doing tort law. There's no contract. Fox and James never signed a contract. All right, so common law tort claims. All right, Hungary mentioned one.
Public
Nuisance. That's right. There's private nuisance, private nuisance claim, and a public nuisance claim. All right. Does anyone know? I remember you talked about nuisance claims for the mining class, right? Do you remember the standard? What is a nuisance claim? What the actual standard is. What is a nuisance claim? What is the claim? Does anyone remember from that class? Do you have your notes from there? Wow.
It is about like the river is public use, right? So if the river has met a public event, it may be uncomfortable to use this river.
Okay, uncomfortable to use.
Yeah.
So the actual standard is substantial. Substantial means a lot. Substantial and unreasonable. Interference. Interference with use of land caused by the defendant. So that's the standard. Substantial and unreasonable interference with use of land caused by the defendant. So do you know the term interference?
Get involved.
Yeah, but you mentioned exactly what it means. It means you're uncomfortable. You can't use it like you want to. It stops you, interferes with you. It makes it very uncomfortable and unpleasant. Uncomfortable and unpleasant to work your land. So he's a farmer. He wants to raise his crops. He has pigs and cows. He just wants to, he just wants to raise his farm and feed his pigs and cows. happily and not have to worry about this water. This water is making it unpleasant and uncomfortable to use his land. This is his private land. He bought this land, you know, he owns this land. He doesn't want someone else's activity to make it impossible for him to use his land. So interference. Does anyone know any other claims? All right. Well, okay, before we do that, let's talk about the difference between private and public. A private nuisance is when private means this is interfering with my private use. My private use. So if he makes a private nuisance claim, he's talking about on my personal farm. I want to farm, raise crops, and I want to feed pigs and cows. This is my private use. The smell and color of the river is stopping my private use. So that's a private nuisance claim. A public nuisance is different. A public nuisance is our public use. Our public use by the community. So these are a little different. A private nuisance, he's making a claim just for his private farm, the use he has on his own land. A public nuisance is talking about our public use by the entire community. So that would be talking about like this nearby neighborhood, people are getting cancer, and if we talk about this as a public land, all these people collectively are being nuisanced by this, they might want to bring a public nuisance claim. So one of the problems with a public nuisance claim is standing. Which means standing, do you remember I gave the definition of standing yesterday?
Yeah.
What is standing?
Right
to sue. Yeah, the right to sue, right to make a lawsuit. So under public nuisance, often you need a public official. You need someone that can speak before the public. It may be hard for a private person to make a public nuisance claim. They need standing. They need to show some kind of damage for themselves and the right to give a public claim. But a private nuisance James can always make a private nuisance claim because it's his own farm. So it will be easier for James to make a private nuisance claim if he just does it for his own farm. He doesn't have to worry about standing. If he wanted to do a public claim, he should talk to the state and try to get some representative. Or he can get other people involved, and maybe many people from the community leaders can come together and claim they have standing to represent the public. Maybe that's possible. Okay. But for a private nuisance, James needs to show personal harm to himself. And the harm is the interference with his land. Okay. So that's one common law claim. Have you ever learned other common law claims? Nuisance is one of them. There are others. I don't know if that will help in this one, because the only statute we have is don't put dangerous chemicals in the river. He might try to sue under this law. So that may be a hard claim because the state already said it's not worried about it.
Teacher, can we say the breach of peace?
The breach of peace?
Free and prior informed consent.
Only if there's a law about it. Free and prior informed consent. We're talking about common law right now. Common law. So these are things that have been in the legal tradition.
Trespass.
Yeah. So one of them is trespass. Has anyone ever read about trespass? What's the trespass claim? I'll use this word. Yeah, intrusion into land. Yeah, without consent. So trespass is normally when a person enters the land of someone else without their consent. Intrusion means entering. Entering when you do not want them to enter. A trespass claim. So, intrusion into your private land. So, could you make a claim that this is trespassing? There's an intrusion into his private land without his consent. Could you make an argument for that, for this claim?
Yeah.
What might be some issues? First of all, how is it getting onto his land? The river is, his farm is right next to the river, but the river's next to him. How do you say it actually intrudes onto his land? What argument would you make? Because the river is out there and his farm is next to it. So he doesn't own, the river is not his river. So the chemicals going through the river aren't on his land. So what would you have to argue to get the trespass?
You cannot stop.
Because we use the river for agriculture this time.
Yeah, but if it wouldn't be trespass unless it's coming onto his land without his consent. So, do you know what I mean? If he goes out to the river and has buckets and took the river in, it wouldn't be trespass because he's bringing it on. But what about it makes it actually trespass? Trespass means it's coming onto his land without his consent. What part about this case, what part about the facts makes it coming onto his land without his consent? Where's the water? Where does he actually get the water from?
The river.
Does he get it from the river?
The well.
The well. The well is on his land. So what he will argue is, the well is on my land. This is where I actually get my water. And I want the water to come in, but this smelly brown coloring stuff that has the dioxins, this is without my consent. It's coming onto my land, into my well, without my consent. So it's very important, if you made something like a trespass claim, you need to actually mention the water is coming onto his land, into the well, into the water he uses. You can't just say the river water is bad. You need to actually have it coming onto his land. So that makes the intrusion part. So the issue with trespass, what might make trespass hard though? If you were a judge and you think about trespass, you know, when you were learning law, you always thought about trespass as like, here's a fence and someone jumps over the fence and enters the land. And now James comes and says, I have this chemical and it's come through the soil, you know, it's come through the dirt and got into my well. What might you think if you were a judge? What would you maybe worry about? These little particles of dioxins. Does something seem hard about trespass as a claim? Is a chemical like a person?
No.
But how is it different?
Can't you say disease?
Yeah.
If you drink your water from your well, before burning is fine, but after the is bad, and then you drink, and then you got cancer.
We'll talk about that in the next claim. That's another claim that we'll talk about next. Right now, we're just talking about the stuff coming onto your land without you liking it. Judges don't like this claim. The reason being is because judges like trespass when there's some person or animal coming onto your land. They don't like pollution because pollution is in the air. And you know, the wind blows over land all the time. No one thinks about air blowing over land as trespassing. So judges do not like little particles coming onto your land considered trespassing. Judges don't like it. Judges don't like pollution as trespassing. So normally what judges will say, it's not trespassing unless it's unreasonable. So one advantage of trespassing traditionally is you do not have to show substantial and unreasonable interference. For a nuisance claim, you need to show there was a lot of interference. It really stopped you from doing what you want, and it was unreasonable. It was like really above and beyond what reasonable people would do. Trespass, you normally don't have to show that. If someone crosses into your land, that's trespass. It doesn't matter whether they are reasonable or not. For the most part, if someone just crosses into your land, it's trespass by itself. But judges don't like pollution for that, and they'll say it's not trespass unless it's really unreasonable, unless they're pumping so many pollution into your land, and then that's trespass. But if they say unreasonable, then it looks just like nuisance. So in practice, trespass ends up working just like nuisance anyway. It's unreasonable release of these pollution into your land. Actually, I want to talk a little more about this term, unreasonable. So, under tort law, there are always four elements to a tort. There's duty, breach, cause, and harm, damage. Harm or damage. So for the nuisance, okay, let's start with duty. Duty usually means a standard of care. You judge it by a standard of care, which means this is what you should have done. Duty means, what duty means is, this is what you should have done. And then you violated it. That's why we can hold you responsible, because you should have done this, but you didn't. So then we can make you pay for the damage. So duty means what you should have done. So there's always a standard of care. And the standard of care is normally reasonable, act reasonably. So be a reasonable person. So for a paper mill, they would say, is it reasonable for a paper mill to use water? This much water, and to have the water look like this. That's what the judge will look at. Is it reasonable? So that's where we get this unreasonable interference. Unreasonable means, are they doing something that other paper mills don't do? If every other paper mill can make paper and not have this chemical going out, then it looks very unreasonable. If Fox Paper Mill is doing what every single paper mill in the world is, or in America, or whatever your country is doing, then it looks more reasonable. So you always measure the act against the standard of care. What should they do? What's reasonable? A reasonable person. Usually is the standard of a reasonable person. Act reasonably, or a reasonable person. What would a reasonable person do? That's the duty. Usually your duty is to act like a reasonable person. But the issue here is this is a matter of opinion sometimes. So you have to persuade the judge that what they're doing is very unreasonable. A breach of the duty means they did not act like a reasonable person. So the breach means they did something unreasonable. And then it caused some damage. So trespass is not a very good claim, because if we have to talk about unreasonable anyway, we may as well just do the nuisance claim, because we have to talk about it. The only advantage trespass gave us was normally you don't have to talk about whether it's reasonable or not. You just have to cross the border. If I just cross into your property, that's trespass. You don't have to look at anything else. That was our only advantage. But judges don't like pollution to trespass unless it's unreasonable. Then it's just like nuisance. So there's no advantage to doing trespass anymore. So trespass isn't a very good common law claim. It exists, but it's not good for this claim. There may be other environmental issues where trespass is better. So it's worth knowing about. Okay, and then we're going to look at the one last claim, which comes up in environmental law a lot. Negligence. Negligence is a common law claim. So negligence is just these four elements by itself. Duty. When you don't have any other way to sue, but there was some harm, you just do the four elements by themselves. Duty, breach, cause, and harm, or damage. So yeah, so then we don't care about anything crossing any borders. All we're asking is the duty, which is the standard of care. The standard equals reasonable. Something like a reasonable paper mill. Reasonable standard of care. So the judge will look at what kind of person are they. So this is a paper mill. So if we want to make a negligence claim, you don't care about any borders, you don't care about physically. All you care about first are these four elements. So the first thing you ask is Fox Paper doing something unreasonable? So their duty is a standard of care to act like a reasonable paper mill. And to find what a reasonable paper mill is, you look at other paper mills. You look at other paper mills or the law on paper mills. This is an argument you have to make to a judge. There's no perfect answer. But the kinds of things you will try to argue about what the standard is, you will look at other paper mills or look at laws on paper mills. If many states pass some law saying paper mills should not use this chemical, then Fox looks very unreasonable. So then the breach is, you want to say Fox violated. Fox was not reasonable. So that's how you would meet these two elements. You would say Fox should have met the standard of care. Look at all these paper mills are not using this chemical, and then they breach. Fox was not reasonable because it did. Well, we have to look at the facts. So, and then we'll talk about cause and harm in a minute. Well, the harm and damage is very easy to show. Negligence is starting to look, since we have to talk about reasonableness and nuisance anyway, then nuisance and negligence are also very similar since we're talking about reasonableness. So James wants to bring a nuisance claim, but it's going to look like a negligence claim anyway because of this reasonableness. They look very similar. So James wants to bring a nuisance claim. So let's just look at the nuisance claim, even though it's very similar to a negligence claim with these four elements, but let's start with interference. How does the water interfere with his life? If we want to make a case. So let's do a nuisance claim for James against Fox Paper Company. And so we want to prove all these different elements. So number one, let's start with interference. So interference means it makes the use uncomfortable or unpleasant.
Unwanted.
Unwanted, yeah. He doesn't do what he doesn't do what he wants to do. This is his own private land. He wants to do what he wants to do, and this is stopping him. Unwanted. So how would you make an argument to a judge? How does this river interfere with his land use? How does it interfere? What would you tell the judge?
The brown water.
Yeah, the water's brown.
The brown water to the well.
What does the brown water do, though? How does it?
It's classifying.
How does it change how he uses his land? So it's interference with use of land. How does it change what he does? What does he normally do, and what does it change? What can he not do because of the water? So compare. What would?
He cannot
Yeah. Why can he not farm? So really connect it. What about the water makes it hard so he can't farm? So the water's brown and smelly. Yeah, and then he has these animals that want to drink and this field that needs water. Does he want to put the water onto the field and give it to the animals? No. And why does he not want to do that? Exactly. Yeah. He's afraid. That's the exact phrase I was looking for. He's afraid. He sees this brown, smelly water, and people are getting cancer, and he does not want to put this onto his field. You know, this is like food. He's maybe growing corn. This is food he's going to sell for people to eat. So he does not want to put a poison into a food that will be sold, and maybe children will eat it. And then there'll be, he'll be in the news saying some poisonous corn, children poisoned by corn from this farmer, and it'll have his face up there. He'll be so sad because his corn just poisoned all his. So he doesn't want to put it in the corn. He doesn't want to feed his animals. His animals will get sick and die. Or even worse, his animals survive, and now this poison's in the animals, and now people eat his cows and pigs, and they get sick. He's going to be crying again. He's afraid. And this fear is this fear is interfering with his way of life. He's afraid to farm. He's afraid to give the animals. But what about his own family? What about his own family? It's not just the corn and cows. Yeah, his own family is drinking from this well. And it's not like they're only drinking it now. For the next 20 years, he's a young man, a young guy. He wants to live there his whole life. So maybe for the next 30 or 40 years, he wants to drink from this well. He's afraid, can I drink from this for the next 20 years? What will happen to me? This is awful water. So I think interference would fall under the harm or the damage. I think it's very easy to give an argument that this is interference. This is definitely interference with his land. It's very easy to argue because he's afraid, so he changes his life because of this fear. So interference is a very easy thing to argue.
Maybe if one of his family member have died for this river, maybe it is more easier for him to.
Yeah. Well, under the facts of the case, that would be very not convenient. That would be awful. It would be a good argument for the judge. So we only have the facts of the case. So under the facts of the case, nearby people, his neighbors have gotten cancer. So he can definitely show that his neighbors have gotten. But if we do a private nuisance claim, he cannot claim damage. Under a private nuisance claim, or even negligence, he cannot claim damage for other people getting sick. He can only claim for his own farm. But he will use the cancer as an argument for why it's interference. Because the cancer explains why he's afraid. I'm afraid because these people are getting cancer. I'm afraid I will get cancer. So that's why it's interfering with my land use, because I'm afraid I will get cancer too, like these other people have. So it's evidence of the interference. But this second question, is it reasonable? Is it? So it's definitely interference with his land. Is it an unreasonable interference with his land? That's the second question. Substantial and unreasonable. So, because this is what Fox will argue. Fox will argue, we understand that you're afraid and that you're changing your behavior because you're afraid. But we will tell you, we have scientists on our staff, and they tell us there's nothing dangerous about this water. Your fear is unfounded. Yes, you may be afraid, but it's only your personal fear. The water itself is safe. So you are irrationally afraid. So yes, we have interference with your life, but it's not reasonable. And so Fox will argue what we're doing is reasonable because this is what every paper mill has to use, these chemicals. Every paper mill has to use chlorine because, you know, paper is white. If you did not put chlorine into the paper, then you would have brown paper. And nobody wants to buy brown paper. You know, every paper mill will go out of business if they built brown paper. So Fox is going to argue, yes, it's interference, but it's not reasonable. It is reasonable because every paper company has to use this chlorine to make the paper white. Is there any counter-argument to that? Another thing, Fox will also say, and look, we got a permit. The state has given us permission to, the state has given us permission to put these chemicals into the water. So it's reasonable. Would you have any argument against that? How might you argue to say that it's unreasonable?
Just the factory needs to use 90% for water. What about if they use 60%? Would that be okay?
Yeah, I mean, there's no perfect answer. We're talking about persuading a judge. But if you show a judge 90% of the river water, it's like this is their private river. I think that's a very good argument. If you say they're using 90%, they're treating this river like it's their own private river. That's very unreasonable for a company to take 90% of river water. I think that's a very good argument. And it would be good to look at other paper mills. Do other paper mills use the same amount of water? If you can find other paper mills that use much less water than that, then that's a very good argument. They're treating it like a private river, and we're paying the cost. What's our time? All right, 5 minutes. Any other good arguments? So, because of this permit, one thing you can look at, the permit is only for the color and smell. But the permit does not make any mention of the dioxins. So that's one counter argument. You can say, yes, you got this permission, you got this permit, but the permit, you know, maybe when this law was passed for this permit, they didn't even know what dioxins were. You know, what if you got that permit 30 years ago? No one had ever heard of this chemical or that it causes cancer. So you could say, you know, it's reasonable for me to be afraid because you got permission before people knew about cancer. That makes me even more afraid because, you know, maybe even, you know, they had no idea when they gave you permission what the risks were. Now we know what the risks are, so now I feel like you have permission to do something risky. So that's one counter argument. I want to know if I have time to talk about 3 minutes. Okay, I'll try to pull this out. So arguments about reasonableness are sometimes very difficult. But especially because he got something like a permit. And one of the arguments here is that many paper mills are exactly like Fox. It's hard to argue Fox is special or doing something unreasonable when many paper mills are just like it. Unreasonableness is a very difficult thing to argue sometimes. So what an alternative to having to argue about reasonableness is something called strict liability. This is an alternative form of negligence, or this is an alternative claim, strict liability. Have you ever read about strict liability? What does strict liability mean? Strict liability, if something is strict liability, you do not need to prove fault. Only cause and harm. So strict liability, you do not have to talk about being a reasonable paper mill and that they breached that. So strict liability takes out these two elements. Strict liability means you only have to prove, were you hurt and did the paper mill cause it? Did the defendant cause it? You do not need to prove fault or unreasonableness. Unreasonable. Do not need to prove fault or unreasonable. Only cause and harm. So this would make the case a lot easier. It would make it much, much easier if they could argue strict liability, because then all they have to prove is Fox caused this water to have these chemicals and I was harmed by it. But we don't need to say they were unreasonable or did anything wrong. The catch with strict liability, remember this is under common law, strict liability is often for very dangerous activities. So under common law, judges will find strict liability for very dangerous activities. Dangerous activities are things like toxic waste or a nuclear power plant. Something like if it blows up, it's catastrophic. So they under strict liability. They say this is so dangerous, we're not even going to ask if you were at fault. If you cause this harm, you have to pay because it's so dangerous. I think we may have to talk about it at the next. We'll continue with strict liability. But I guess I'll ask really quick. Does a paper mill sound like a catastrophically dangerous industry? They make paper.
Yeah.
When you think about paper, do you think about catastrophic apocalypse, the world ending? It's paper.
Tissue.
Tissue, yeah, it's made out of paper. Does it make you scared to death like a nuclear catastrophe? If you were a judge and someone held up a piece of paper, would you be scared to death of a catastrophe? Yeah, so it's a hard argument to make strict liability because paper just doesn't sound very dangerous. All right, well, we'll continue with Ford James and Fox Paper Mill in the next class.
Can I